So what do you do to keep a case going or to move a case forward that's stuck in neutral? We get this question all the time from clients, but also people, especially in social media, and from our Illinois Divorce Support Network, our private Facebook group. And this is a very common problem. Here's a question that came up in the Divorce Support Network that is a typical example. Almost 2 years in, and the judge keeps allowing STBX more time for discovery. I've sent discovery 3 times, the marital settlement agreement, which states we each keep our assets and debts, parental responsibility agreement. I'm guessing this means drafts, etc. We hear absolutely nothing from his side. We've done an order for motion to compel discovery and sanctions. That means forcing turnover of discovery responses, and a petition for rule to show cause, which is a motion asking the court to hold the other person in contempt of court, and still nothing. How is he allowed to keep this going on? My attorney says she's just as frustrated as I am. What do I do? Okay, this is a common problem, like I said, and obviously very frustrating. Part of it depends on the county you're in. Now, I'm guessing if it's gone on this long, this is a Cook County or Chicago area, immediate Chicago area case, because cases in Cook County can take 2+ years to get to trial. And the problem is, it sounds like there's no trial date set here, so there's no motivation for people to get closer to being done. And if the court isn't helping move this case forward, you've got problems. So what can you do to move a case forward? Well, the number one thing is comply with everything so that there's nothing the other lawyer or other party can point to say you haven't done. For example, make sure your discovery responses are done. Make sure they're up to date. Your financial affidavit is complete and submitted, and that you've dotted all your I's and crossed your T's to be ready. One thing you can do is take the deposition of the other party, which will make the other lawyer and the other party look at this case and actually pay attention to it. And nobody likes to testify for their deposition. It will cause them some discomfort and make them actually think about the case. And a lot of times it provides a good avenue to talk about settlement. Once you've got all these things done, the discovery is complete, then you can ask the judge for a trial date. So once you've dotted the I's and crossed the T's by getting discovery complete, by getting deposition done, and being ready with all your documents, now the court's willing to give you a trial date. And by setting that trial date, you can get the case advanced and get it complete. It's not necessarily that you're going to have the trial. Very few cases actually go to trial. What is going to happen is going to motivate people to get more done, get closer to being complete, and pay attention to the case because you've set that trial date. What it does is it shows people there's a line in the sand and they can't fool around anymore and delay. And now they've got to pay attention to getting it done, or the judge will make a decision for them at the trial. So the best thing I can say is get all the things done that you're required before you can get a trial date, get the trial date, and advance the case. This costs money and takes time, but it's the only way to get it done. Otherwise, you're just sitting around waiting for things to happen. And if the other party isn't motivated, nothing's going to happen. Please keep the questions coming. Thanks very much. I'm Raiford Palmer.